Yeah, so these three amendments remove what is known as the demonstration test to demonstrate that these are hate crimes, and therefore the crime itself becomes aggravated by hatred. Again, this is pretty unusual in criminal law, that you're not relying on motivation, and instead you are seeking simply to rely on demonstration to establish that a particular offence was aggravated by hatred. We think this is a significant problem. It heightens the risk of abuse of this section. It means rather than having to prove that hatred was a motive for abusive or insulting behaviour, for example in relation to public order offences, all a Garda would have to do is say under oath that someone used a racist or sexist slur during or immediately after abusive or insulting behaviour. We know that the word of a guard in the courts would carry a lot of weight, and it is explicitly stated it is immaterial whether or not an accused person's hatred is also on account of any other factor, which therefore states that you could have that the expression of hatred, the alleged expression of hatred, is purely incidental, happens after the fact, and is not related as a point of motive. There's a very interesting paper by Jennifer Schwepp and Amanda Haynes, which deals extensively with the question of the demonstration test. They point out that the demonstration test is not used in hate crime legislation anywhere else in the world apart from the UK, Singapore and Malta. They point out that it can lead to a disproportionate level of convictions of people from oppressed minorities for hate crimes, ironically, and that is precisely what has happened with black people in the UK. And they also show how being convicted of a hate crime creates a stigma and can prevent people from finding employment, meaning that wrongful convictions for any form of hate crime have very serious lifelong consequences for people. And so we therefore are opposed to switching motivation for simply demonstration. A classic example of this would be someone involved in a public order offence. Let's say we understand that the offence actually happens. In the aftermath of that offence, they say a racist or sexist slur, which obviously they shouldn't. They should be condemned for doing so. But the truth is, while that's very unpleasant, while we don't want people to be saying racist and sexist slurs, the fact that they use a racist or sexist slur after committing a public order offence doesn't prove that the public order offence itself, that offence was aggravated by hatred, that the hatred that they expressed afterwards had any relationship to the public order offence that they committed. And yet, that's it. With the demonstration test, the state will not have to prove motivation. So again, it's just like the section, what was it, 11, the thought crime element. It's very, very problematic. Just to quote from the paper that I referenced, they report on views of Irish criminal justice practitioners on the demonstration test. They say that although some consider that motivation was more challenging to prove than demonstration, which is the case I presume the Minister will make, a substantial number of the practitioners to whom they spoke nonetheless argued that the demonstration model is too low a threshold for an aggravated offence. To quote a barrister, there might be many reasons for somebody saying X inadvertent or otherwise, I don't know. But to actually prove motivation, I think it's harder. So if I'm looking at with my defence hat on or with my constitutional hat on, I think I'd prefer that. At the same time, it was noted that lawyers in Ireland are not unused to the challenge of proving motive. Quote, so for instance, as you know, the legal position is it's not necessary to prove a motive. It is helpful if you do. What a prosecutor is worried about is if you have a crime for which there is not a motive, a jury may look less favourably on it in the case of the accused. They say criminal justice practitioners who participated in our research expressed concern with respect to the utility and application of the demonstration test in an Irish context. Gardaí, who prosecute most crimes in lower courts, were largely confident about their ability to prove a biased motivation, readily identifying the types of proofs whose presence could be probed during investigation. And that's, I don't think the case has been made to move away from the general rule of proving a motivation, proving an intent, along with an act in terms of criminal law, to reduce that requirement and simply to have a demonstration test replace it. I think if we're looking at crimes that are aggravated by hatred, well then the onus is on the state to prove that that happened, and there's lots of ways to imagine how that can be proved. The actions of somebody in advance of a public order incident which is genuinely provoked, genuinely aggravated by hatred. The things that they say in the course of that. Perhaps the sort of material that we were talking about earlier being on someone's computer. There are lots of ways that you could adduce evidence to make the case that this particular crime is motivated by hatred and therefore should be an aggravated offence, as opposed to simply relying on the demonstration of hatred in the course of or in the aftermath of that.
Thank you, Karen Corley, and I thank the deputies for their contributions. And to add some context to my response to this amendment, I would briefly like to outline the House the position that has been taken in the bill with the adoption of what is commonly referred to as a demonstration test. A particularly robust process was followed to ensure that this legislation is as effective as possible. Considerable research and consultation was conducted by my department in collaboration with counterparts in other jurisdictions and with the Office of the Attorney General and the DPP in relation to the appropriate tests of proof for the new hate crime offences. The inclusion of a demonstration test of proof was first and foremost a key recommendation from the Oireachtas Joint Committee on Justice in its report on pre-legislative scrutiny of the general scheme for this legislation published last April 2022. The report recommended the addition of the demonstration test in addition to the motivation test, which was previously set out in the general scheme. This recommendation was echoed in numerous submissions to the committee from civil society groups and academics with significant expertise in the area. The change of policy to include a demonstration test in the bill was agreed by government last July. The demonstration aspect of the test hinges on a perpetrator demonstrating hostility towards someone with a protected characteristic at the time of an offence being committed. To give some practical examples, this would include the use of a hostile or prejudiced slur, gesture or other symbols of graffiti at the time of an offence being committed. The substantive difference between the demonstrative model and the motivational model is that under a demonstration test, the prosecution must prove the demonstration of hostility, but no subjective intent or motivation is required. It is an objective test. A motivation test requires proof of the defendant's subjective motivation for committing the offence, which can set a higher bar to secure a conviction. Use of a demonstration test in proving hate offences will make it easier for An Garda Síochána to investigate potential hate crimes right from the beginning, and the hate element of the offence can then be presented and challenged in court if deemed appropriate. In their amendments, the deputies seek to remove the demonstration test in the context of all of the aggravated offences in parts 17, 18, 19 of the bill. I regret I cannot agree to these amendments. As I have set out, the demonstration test plays a very important role in hate crime legislation, and experts and academics agree that it is the most effective tool in ensuring that convictions can be secured where hate crimes have taken place. Furthermore, it was an express recommendation of the Joint Oireachtas Committee on Justice, and inclusion of the demonstration test was agreed by Government after the committee published its recommendations last year. I hope the deputies can appreciate that Minister Harris and I want to ensure that this bill, once enacted, can be as effective as possible and to provide marginalised communities with the reassurance that individuals who perpetrate crimes against them will be held accountable. Deputy Daly raised a particular point around minor public offences, and if these type of offences may be dealt with at a local level by a superintendent or member of An Garda Síochána. While it is true that certain low-level offences may routinely be dealt with at a Garda station, this legislation deals with comparatively serious offences that would not be suitable to be dealt with in this manner. Section 18 of the bill creates new public order offences that are aggravated by hatred, which on summary conviction that would make the offender liable to a Class C fine or 6 months imprisonment or both. All 12 of the specific offences that may become aggravated by hatred carry an uplift in the potential penalties for offenders that are summarily convicted in comparison to the ordinary version of the offence. Cases such as these would have to be dealt with through the court system and not An Garda Síochána. Thank you, Councillor Corley.
I mean, I'm not convinced by the Minister's response, obviously. I think that, like, so at the end, the Minister outlines the consequences of being convicted of a hate crime. You get a higher sentence, you get labelled as a hate criminal. It's a serious thing. Therefore, does it not make sense that we try to ensure that people convicted of a hate crime are people who actually committed crimes motivated by hatred? And like, that's explicitly not what the legislation seeks to do by using a demonstration test. And I want to be clear, like, if we had instead a motivation test, clearly, you know, sexist, racist, hateful things being said in the aftermath of the offence itself could be taken into account in trying to determine whether a motivation was present or not. But simply the demonstration of hatred at the time of committing offence or immediately before or after doing so, simply that by itself, like, it just doesn't logically mean that the actual act of an offence, the kind of incident that many deputies have spoken about, of a fight, public order incident or whatever, that itself was aggravated by hatred. And we are talking about a serious issue here in terms of the impact that it has on someone. Obviously, we are eager to have proper legislation that does properly punish with extra sanction assaults, etc., serious crimes that are aggravated by hatred, that are inspired by, motivated by hatred. But it seems to me that a certain shortcut has been taken here, which is not helpful, and means that we can bring into the net and label people as hate criminals who in fact, that wasn't the motivation for the crime that they committed, although they may well have said something that is reprehensible, should be condemned and so on, but it doesn't change the nature of the offence that they may have already committed.
Anyone else? Minister?
Thank you, Councillor. I acknowledge everybody here wants to get to the same place where we can, I suppose, seriously discourage hatred and speech, and that is not going to happen, and that minorities are protected. A lot of consideration was given to the difference between whether to use the motivation approach or the demonstration approach. The Joint Oireachtas Committee was very clear that they wanted to see the demonstration approach taken into account. I think it has been effective in other jurisdictions as well. So it has been. I think proven motivation is exceptionally difficult in court. And speaking both from somebody who practiced in the law library as well as in terms of the research that's been done in relation to this. And it's about finding that balance to ensure that those who are demonstrating hatred are actually held accountable. And so in our view, this is on balance the more appropriate and better approach to take. Thank you.
Yes.
Yeah, just briefly, I just want to make a pretty short general point that, look, we were in favour of having good hate crime legislation. I think the work done by those in the Coalition Against Hate Crime Ireland has been excellent. Obviously, a lot of the groups there are coalitions that we organise with, through the likes of Lecala, Ireland for All, and so on. But this, the Section 10 thought crime section, and the failure to insert an explicit reference to the right to freedom of expression by virtue of Article 10 of the European Convention on Human Rights means that, unfortunately, we won't be able to support this legislation at this stage.